I guess Mass of New Hampshire. This meeting is, okay, good. It says continue. Okay, good. So we're dealing with Mass of New Hampshire, folks. Some of you have a Massachusetts, well, you all have a Mass license. Excellent. And some of you have a New Hampshire license already. And some of you want it. Very good. If you have a Massachusetts license, then we have a partial reciprocity program with New Hampshire. So you actually don't have to take a course at all. You take the test and you will fail. You really need to, take some type of a course to pass, because the laws are really different. We'll go over some of that today. We have continuing education. New Hampshire requires 15 hours, 12 hours of electives, and a 3-hour core. And people always call me, is the core, if you take the core, Andy, can I get credit for Massachusetts too? No, it's called a New Hampshire core. It's 3 solid hours purely on New Hampshire rules, regs, and practices. In New Hampshire, if you take the core and only take the core, you maintain your license on the shelf. You cannot practice with the core. So all you can do is prevent what happened to Debbie. If you don't want to practice in New Hampshire any longer, you have the license, you hate it. At least take the 3-hour core, and that will allow you to maintain your license without losing it completely. If you choose to no take core and you let more than 6 months pass, you lose your New Hampshire license and have to start from scratch. So New Hampshire requires 12 hours of electives. It's any 12 electives that you want. All the classes I teach with you guys, almost 99%, all of them I would say, are good for both states. So if you're in one of my classes and have a New Hampshire license, you should be letting me know so I can prepare you a New Hampshire certification. We have, there's one new law in New Hampshire, be careful. If you're a first-time licensee, you just got your New Hampshire license, which some of you will. Starting in February of 2022, you need 15 hours, 3-hour core, which leaves you 12 hours. Those 12 hours must be in very specific subject matter. You can't come to just any course you want. You need first-time licensee classes. And I offer those classes as well. So someday I'll be talking to Kathy when we get closer to February, and we'll throw some of those in. Those first-time licensee classes are good for any New Hampshire agent, even if it's their 100th time. And they're also good for Massachusetts agents as well. It's just, they're very specific courses that you first-time people have to take. And the reason is, the state says, listen, when it comes to like advertising, you first-time people are really messing up bad. So you're gonna have to take a class right out of the gate on advertising because you're screwing it up pretty bad. Another problem with first-time agents, they don't understand the code of ethics. It's ridiculous. So they're making you do an ethics class, which is good for continuing ed as well, but ethics. And then they have agency and a few others. Anyway, the purchase and sales agreement in New Hampshire, never use a Massachusetts P&S on a New Hampshire property. 2 different animals. One of the biggest differences on these forms, because all purchase and sales have to be somewhat, similar. You've been in my contract law class and my purchase and sales class, and we go over the Mass form with you guys. But the New Hampshire form is a different animal. One big difference here is it doesn't say you have to accept the offer on or before a certain date. So you go, all right, I want to buy Tony's house over in Fitchburg, 25 Main Street. I'm making an offer. I want to pay $500,000 for Tony's house. So I fill out my offer. And then Tony's the owner. He looks at the offer and he just looks at it and doesn't sign it. You go, all right. He doesn't even counter me. There's no counter offer or anything. And I'm wondering, what's going on with Tony? I gave him the offer like 3 days ago. I haven't heard from Tony. Now it's 5 more days. It's been like 8 days. I haven't heard from Tony. It's like a year and a half. I haven't heard from Tony. Where's Tony? This contract is still valid. The contract doesn't have a self-extinguishing date like a Massachusetts contract. It doesn't say on or before Wednesday at 11 o'clock, this contract will survive. So you really have to have an attorney write up an on or before clause and put it in the special provisions. So that's weird because your buyer's gonna go, what's going on? Another strange thing with this one, which is totally dangerous, really bad. Oh, look at this, before I get to the bad. They have a beautiful contract in this respect, the inspections. On their contract, you can check off what inspections you want. Does the buyer want to do a radon? I don't know, maybe not. Lead paint, pests. So that's a little different than your Massachusetts form.
And Andy, if I could, are you showing us the forms on your screen? Because I just see a menu. Or am I missing something?
Yes, no, I'm showing the form. You don't see it?
Yeah, I just see the menu with the PDF files.
And let me screen the share again. I'm glad you said that because that doesn't make sense. Tell me what you see now.
Now I see it.
Yay!
Sorry.
I'm glad you know. Sorry. Does everybody see it?
We do.
Yay! Okay. So this is their form, New Hampshire standard form. This effective date is different too. That's the date that the seller actually signs it. So from that day forward, if you have a 10-day home inspection, you're counting the days from that day forward. Because you got to know what, I don't know what date we're talking about. So now, so we got that. Oh, what else did I say? Oh, look at this. This is the inspection stuff. Check what you want. Beautiful. Boom, boom, boom. I don't want it. I do want it. Here's another one over here. This is really, there's some due diligence. You can agree to do some due diligence and check off the due diligence you're interested in doing, like a condominium due diligence or easement due diligence. Watch this one. Where'd it go? Oh, this is the bad one. Liquidated damage clause. In Massachusetts, we have a totally different liquidated damage clause. The liquidated damage clause in Mass says, if the buyer shall default in the performance of their obligations under this contract, the sole and only remedy the seller has with the buyer is to keep their deposit. The sole and only remedy in Massachusetts, the seller keeps deposit. Look at New Hampshire. If the buyer shall default in the performance of their obligation under this contract, the amount of the deposit, what's the bad word here? You see my circle thing going around the screen? What's the bad word? Deposit, what's that word?
May.
Wow, that's pretty bad. The seller may, at the option of the seller, become, the deposit may, at the option of the seller, may become the property of the seller as a reasonable liquidated damage. May, Kendra, that means there's probably a may not. If there's a may, there must be a may not. So what if the seller chooses not to keep the deposit as the liquidated damage, as the damage? The seller might then say, no, I don't like liquidated damage. I'm not going to do that. I have an option. I am going to come after you for consequential damages. Kristen goes, what the heck is that supposed to be? Kristen, I'm sorry, but you made an offer on my house. You backed out at the last minute. I don't want to keep your deposit. I want to destroy you as a human being. I bought another house. I have another mortgage. I expected this to be sold to you, but you pulled the rug out from under me. Now I have 2 mortgages to pay, and you're going to be the one paying the mortgage on this house you chose not to buy until I can get it sold again. And Kristen, you know what else? The market went down the tubes in the past month. So I'm not getting the $400,000 you were supposed to pay me. It's only worth $350 now, and I'm suing you for that as well. So those are called consequential damages, and those are allowed on the New Hampshire standard form. Unless, Deborah, an attorney crossed out the bad words to protect your buyer. And the problem in New Hampshire is most agents don't use an attorney in New Hampshire. They use these stupid title companies, and there's nobody reviewing the contract before it moves forward in the transaction. And all of your buyers and sellers are stuck with the standard form, and it is not drafted to protect the buyer at all. So there you go.
I have a question.
There's that one. Another
Andy.
thing you need to know about is the agency disclosure form.
Andy, real quick, can I ask a question? Going back to the
Please,
PNS?
while I'm setting this up, go ahead.
Okay. So in Massachusetts, more often than not, we all use attorneys. In New Hampshire, is it considered bad form to insist an attorney review the PNS?
Absolutely not. In Massachusetts, New Hampshire, Connecticut, Hawaii, if you are one of the 1.4 million members of the National Association of Realtors, you are obligated under Article 13 of the Code of Ethics, which says realtors must recommend an attorney be involved in the real estate transaction. So it is our obligation to make sure, no matter what state you're in, that the attorney has been contacted to benefit your buyer or seller.
So then
So,
in New
nope.
Hampshire, they'd have an attorney fee and a title company fee.
They would have, you don't need the attorney closing the deal, that
Okay.
attorney, but you need the attorney to review the purchase and sales agreement before you're legally bound for the rest of your life in this contract with consequential damages that can be ridiculous, or a liquidated damage problem that could cost you quite a bit too. So yeah, you need a lawyer. That's why the Code of Ethics says you need a lawyer. Stop
Right.
it. Recommend a lawyer. Code of Ethics was written because they realized their members need to protect themselves. And the best way for us to do that is be able to blame someone else. If the buyer's mad at you about the contract that you drafted, because you guys are the ones filling it out, wouldn't it be nice, Stephanie, to say, I may have filled out the boilerplate contract, but you had an attorney review it before I passed it on to the seller. So don't blame me. Isn't it nice to say, blame the home inspector? He's the one who looked at the boiler, not me. I think that's next week's class. We're going to talk about what's going on with home inspection law and all this waiving of inspections. Let's see, that's next week or next month? I don't know, but it's set up.
Next month.
Next month.
Yep.
That's a really good one. I got some juicy information on that for you guys too. Okay, so now, agency. I want you to see the big difference. These two forms are night and day. You use the wrong form, that's bad. You see anything on the board? You see me flipping through stuff?
Yes, we do.
Okay. So this is the Massachusetts form right here, right? I hope this looks familiar to you. That would be like the first step. This does look familiar. This form must be presented. It says right over here, the time when a real estate agent must provide the form. All real estate licensees must present this form to you at the first, you see it, Stephanie, Kristen? At the first personal meeting with you to discuss a specific property. So, Rick, if I meet you at the gas station, I'm pumping, I don't know you from a hole in the wall. Well, you're pumping gas, I'm pumping gas. And you say, hey, the guy says to you, hey, you look like a real estate agent. Do you see the stress on my face? Obviously I am. Well, what do you need to know, sir? I am an agent. And the guy wants to know information about a house you've listed down the street. He knows it's your listing because he saw your picture on the sign. He goes, you look familiar to me. What do you want to know, pal? I want to know how much that house is selling for. What do you have to give this guy before you discuss that property?
Agency disclosure.
Yeah, what if he called you on the telephone instead? Wasn't the gas station? Do you have to give an agency disclosure form?
Yeah, email it to them.
If your office policy, Matt, says, if your company says, I want you to provide them with a form, even on the phone, then you have to. But the law doesn't say that. The law in Massachusetts says at the first personal meeting. Now, because of COVID stuff, this is going to be, this is a debate going on right now in the real estate world. What is a personal meeting? Is it a Zoom meeting like we have right now? Is that a little thing on the telephone? Like, hey, I see you. Is that a personal meeting? So right now, Massachusetts has not identified what that really means as far as the technology and the Zoom stuff. So far we can still say that means a face-to-face. Now, what's a face-to-face? Is that on a Zoom? I see your face. Kendra, I see your face. Is this face-to-face? So very soon, this is going to be face-to-face, but right now, they have not changed the spirit of their original intent, which is, in person. But anyway, I'm bringing that up because you have a discussion in person in Mass, you must give this agency disclosure form.
Hey, Andrew, isn't there a thing with, it's like a implied agency even before the whole COVID situation?
Oh, there's always implied agency. Implied agency, accidental agency is allowing a buyer, for instance, to believe you are working for them. They actually believe that you're supposed to be giving them real estate guidance and working in their best interest. And that happened by accident, Matt, because you were acting like you were helping them too much. If you don't truly represent a buyer, don't be helping them to the level that seems as if you guys are dating. So you got to back off. Otherwise they believe, is this a date? I think this is a date, right? Like we're at the movies, like, man, no, no, this is a date. It feels like a date. You just put your arm around me. This is a date. So you really can't cross the line, and that creates accidental agency. But just having a conversation does not create it. It's what you say and what you act like. But anyway, let me go over this for 1 second more. The big difference in Mass and New Hampshire is the form is totally different, totally different. In Massachusetts, we have to check off, are you a seller's agent, a buyer's agent, or a facilitator? Take your pick. It's not the same in New Hampshire. Now, there are big differences between the two. In New Hampshire, let me get it. This is the New Hampshire form. In New Hampshire, this is the relationship disclosure form. When I hand this to the buyer, to the prospective buyer, the guy at the gas station or wherever, it says, right now, dude, you are a nothing. You are a customer, and I don't want to create accidental agency. I don't want you thinking I'm doing more than I am, so back off and get your arm off of my neck. Right now, you are a customer, and it says, as a customer, the licensee you're working with, me, I'm not here for you. I don't give two diddlies about you. I will be honest with you. I'll disclose problems that I know about with the house you like. I'll talk about the house problems that I know. But I'm not helping you negotiate, and I'm not your fiduciary. So get over yourself. That's what it says. If you want me to take you on a date and become connected, then you're going to have to become my client, not just my customer. And if you want to become my client and I become your buyer agent, then you need to sign a written contract. This is a huge difference in Mass and New Hampshire. In Mass, if you want to be a buyer's agent, you don't legally need a buyer agency contract to do that. In New Hampshire, the law requires you have a written contract to be a buyer agent. Must be in writing. Now, everyone in this room, even in Mass, Kendra, Kristen, even you guys, Rick, even iPad. I see iPad right there. That's good. That's like the new name people must be naming their children. iPad. I've seen a lot of those names up lately. So iPad, I forget what I was saying. I get into the iPad thing for a second. I lost my train of thought. Oh, to become a client in New Hampshire, you have to absolutely sign a written contract. But everyone in this room has to have a written contract to be a buyer's agent, even in Massachusetts. I just said to you, the law does not require it. That's true. But I also said everyone in this room must have a buyer agency contract to represent a buyer in Massachusetts. But I can't say that about every room I teach in. I could say it about this room. I guarantee it, I believe. Every one of you, I am assuming, is a realtor. Is that true? A realtor, member of the association, national. Guess what it says in Article 9 of the Code of Ethics? All realtors must have a buyer agency agreement in writing. In writing. But anyway, so in New Hampshire, the Code of Ethics requires, in New Hampshire, the agency disclosure form, it says that you're a customer unless you want to kick it up in contract. Let me show you the most important part of this. Right over here. Look at this. You see my little thing here? Right here. This form shall be presented to the consumer at the time of the first business meeting. Debbie, it doesn't say at the time of the first personal meeting prior to discussing a specific property. It doesn't say that. That's what Mass says. This says at the time of the first business meeting. So New Hampshire has a definition of business meeting, and it means any time you are discussing that property on the telephone, on an email, in a text, in person, on a smoke signal, any way you are now discussing the property is a business meeting. If Raj is in our hot tub naked at the gym discussing real estate, that's a business meeting. So the problem in New Hampshire is I'm on the phone in Fitchburg. Yeah, you want to look at a house in Fitchburg? Oh, yeah. Oh, 25 Elm Street. Yeah, that's an awesome house. Yeah, it's going for $300,000. I can talk about it. I don't need agency disclosure form. Oh, no, you didn't mean Fitchburg. Oh, you meant Nashua, New Hampshire. What do you want to know? Everything is different now. Matt, what do I have to digitally send these people? Some digital means.
Yeah, the New Hampshire what's on the screen right there.
Agency disclosure form, right? Exactly. If you fail to do that in New Hampshire, you're going to sit before the board. You want ever to sit before any board bad. Board bad. You don't want Mass or New Hampshire board to know you exist. So there's a big difference between agency, Mass and New Hampshire. Form's different. When to present is different. Another big, gigantic difference in Mass and New Hampshire would be fair housing law. They have different protected classes that we do. Fair housing. Okay. You see that on the board too? Now, once you guys get your New Hampshire license, you need to put an additional poster on the wall in your office. Right now, your office absolutely needs to have the federal poster, the fair housing poster. You need the Massachusetts fair housing poster. This is the new one you'll need once you have a New Hampshire license. You need the New Hampshire fair housing poster on the wall. Now, there is a difference between the two. These are the federal fair housing protected classes: race, color, religion, sex, handicap, national origin, familial status. Okay, 1, 2, 3, 4, 5, 7 of them. This is Massachusetts. 7 plus age, sexual orientation, marital status, veteran status, ancestry, and Section 8. Public assistance. So Mass was kind enough to add many more protected classes. Let's see what New Hampshire did. Right here. New Hampshire, they added these additional protected classes, but not all of them. They do not protect veterans in New Hampshire. They do not protect Section 8 in New Hampshire. So a landlord in New Hampshire can actually say, I don't rent to Section 8 people. In Massachusetts, you're going away for a long time by saying something so stupid. In New Hampshire, you can say, Kenneth is a Marine, and I'm not renting to Marines in New Hampshire. That's okay. But in Massachusetts, that would be a problem. So we have veteran status, public assistance, 2 different issues, and the posters are totally different. Don't mess that up. Any questions so far? So what do we recap so far? We got the big difference on the contract. Liquidated damage clause is crazy. And you're able to put in all the individual inspections you would like to have. Agency is quite different. We have a totally different form. We have a form that right out of the gate says you're a customer, and to be a client, you must have a what?
Written agreement.
Yes.
Written agreement.
And if I call you on the telephone and I need to know something about a house in Westford, do I need an agency disclosure form sent to me?
No.
No. Now I discuss a house up in Londonderry, New Hampshire.
Yes.
Yes.
Yes. Very, very good.
Quick question, Andy. Again, sorry, I'm that
Oh,
person.
you kidding?
Have you heard of any thing trickling down the pipeline about changing those 2 excluded protected statuses in New Hampshire? Like veterans really surprises me.
Not right now. No, they move pretty slow. But nothing right now. There is no bill on the table to add that to the list.
Okay.
Not right now. You know, if you discriminate against a veteran in New Hampshire or any other state, let's say New Hampshire, it's not protected under fair housing, but someone could still say that you're treating people differently. And that can be, you know, a general violation of some constitutional rights people have to be treated, you know, equal. So you really don't want to step on someone's feet, especially a veteran. Probably got a gun.
Thank you.
So you want to like calm down. Plus they're the veteran. What did they do? Here's the issue with the veteran, why it was an uphill battle to get it on the Massachusetts list, but it's there, and why some states haven't done it. Because landlords want to have the right to not rent to a veteran. And the reason is post-traumatic stress disorder. There are many veterans, and they tell you, and there are commercials on every day, wounded warriors will say to you, I don't have a physical disability, my arms are intact, but I have a serious post-traumatic stress, PTSD. And the PTSD means I get mad quite a bit when I have flashbacks, and I need medication, and I get wild. So that's what scares some landlords going, I don't want that to happen in my building. So that's why some landlords say, I've been a landlord for forever. I'm 60, I've been a landlord for 42 years. And my tenants, I've had many veterans. I've had good luck with them all, except one. One guy went nuts. One guy was vicious. He would have flashbacks about Afghanistan, about all the bad stuff he ran into there. And he would flip off, and the other tenants would have to call the cops, and they'd have to handcuff him and take him away. And he was in a rage. and then he would be calmed down. And this happened mostly in the summertime. He said that the warm weather, when it got really hot and he started sweating, he went back in time and his mind just freaked out. So people say, why wouldn't everybody welcome a veteran? That's probably why. Some people just are a little bit nervous because they've had some bad experience. But in mass, veterans are protected, period. Don't mess around with them. I can still reject a veteran if I find out from their previous landlord the guy was arrested 5 times and for you know, hitting people in the hallways. That's different. I'm not going to arrest somebody who's dangerous. Anyway, okay, so we have different fair housing law. Another big giant ticket. This is huge, and it's the lead paint law. Totally different animal. Lead paint forms in Mass and New Hampshire are not the same. If you use the Massachusetts form in New Hampshire, you're in so much trouble with the EPA, it's disgusting. It's bad. You'll be fined tens of thousands of dollars. It's really bad. Same thing if you use your New Hampshire form in Mass. Now, I teach the lead paint class in Seabrook, New Hampshire, right over the border from Massachusetts. And I focus on these students to be careful what box you're grabbing the lead paint form in. Don't make a mistake. You're going down if you do. In New Hampshire, let me get to the right section. New Hampshire changed its lead paint laws, 247, a lot in the past few years. Massachusetts just changed its lead paint forms a lot in the past 2 years, even double a lot. So that if you went to lead paint class 2 years ago, it's not the same class, is it, today as it used to be. Now, there's a level of lead. Let me just get to this stuff. I'll get to that in a second. In Massachusetts, you have a kid under the age of 6 moving into an old house built before what's the year again?
78.
78.
Beautiful. So if it's a house built before 1978, you're in the safe zone. If it's built before 78, Matt, and the birthday of this house we speak of,
It's January
how do I know
1st.
the birth date?
January 1st. Every house is considered January 1st.
No, that's a good one. Everybody has an answer,
That's
which is great.
thoroughbreds.
What?
Yeah, that is thoroughbreds.
There you go. Perfect. It would be based on not the occupancy permit, the building permit. So when you guys are making your determination as to whether you need a lead disclosure form or not, you do not need it. It's an NO need, no need, if it was built in 78. And Kenneth, you know the date by looking at the first building permit. Okay. So we have, in Massachusetts, you have a house built before 1978. It's called a target property. All over the country, that's the term, target property. Built before 1978, kid under 6 years old, not 6. A 6-year-old can lick all the paint they want. It's under 6. So a kid under 6, target property. That house must have a lead certificate. That means it has to be de-leaded. The lead inspector would issue a certificate of compliance. This is not a should have or a good idea to have. This is a must have. If I say, Kristen, you want to drive a car? I'm not going to say it's a good idea that you get a license, a driver's license. No, you must have a driver's license. Same thing with lead. So in Mass, you must have a D-lead cert if the kid under 6 lives there. In New Hampshire, they do not have that law. So in New Hampshire, you got a target property, 5-year-old, you do not need a lead cert. There's nothing wrong at all with letting that kid live there. The only time the state of New Hampshire will force that unit to be lead certified is if the kid becomes lead poisoned. So in New Hampshire, they wait for the kid to be poisoned. Then they respond. That explains why a lot of people in New Hampshire, they're not quite with it. So you got, in New Hampshire, you wait for the poisoning, and then you enforce the de-leading job. But that does not apply to single-family owner-occupied people in New Hampshire. So even if your kid is poisoned in New Hampshire, old house, the state cannot force you to de-lead it. In Massachusetts, every residence where a kid lives, owner-occupied, rental, condo, it doesn't matter. Even the house that Laura owns, it's her house, and her kids, it's her house. You need a lead cert. In New Hampshire, you do not. Even if your kid's poisoned in New Hampshire, the parents of a single-family home cannot be forced to de-lead, but a landlord would be forced, and they would have 90 days to get it done. Now, big difference here. A kid in New Hampshire is lead poisoned when their blood lead level is 7.5 micrograms per deciliter. In Massachusetts, a kid is poisoned when the blood level is 10 micrograms per deciliter. But in New Hampshire on July 1st, 2021, the law is lowering the level to 5 micrograms per deciliter. So in New Hampshire, kids will be more poisoned. Number one, they don't have the law that requires it be lead certified. Plus, the level of what's considered lead poisoning is much lower and easier to achieve. So New Hampshire, they got a 5, which you might as well say 5 because July 1st is right around the bend. 5 micrograms. In Mass, it's 10 micrograms. Hey, Ken, Mass used to be, 2 years ago, 25 micrograms. They went from 25 to 10. So they're probably going to stick to 10 for a while. Anyway, so there's the big difference between the lead. The form is different. The lead paint laws are different. Occupancy regulations. De-leading a house in Mass is so much cheaper than de-leading a house in New Hampshire. In New Hampshire, we need to remove the lead on the landlord's houses that get caught for a poisoned kid. The state mandates they remove all the lead. They have to come up 5 feet, 4 inches back from every biteable edge. Everything that's biteable, where you could wrap your little mouth around, has to be scraped down to the bare bottom. That is all the windows, all down here, the sill, the apron, the window, all that's got to go. On the outside, all the biteable surfaces, the railings, the spindles, the balusters of the steps, all has to be dealt with. A single family home in New Hampshire having to be lead certified, 2 bathrooms, 3 bedrooms, $50,000. In Massachusetts, the new law does not require any of this be removed. The new law in Mass says when I give you a lead cert, I don't care about all of this biteable stuff anymore. The only thing they make us de-lead now is the window sill, not even anything else, none of this, not just the sill. And they make us stop peeling paint, just clean up the peeling paint, just clean it and paint over it. They make us replace windows that are old, but many houses today have the newer windows anyway. So most houses I go in and work on, it's only the window sill. And on the outside, there's no more balusters, railings, all that. So all we do in Mass is window sills, hand railings on a stairway, just the stupid top part, not even the balusters or spindles anymore. In the step of a stairway, like a stair, just the step, not the rise board, just the step. And all I do is carpet over it. I'm done in no time. So in Massachusetts, to de-lead that same house we just mentioned, 50 grand in New Hampshire, in Mass, that would be 6,000. night and day. So if you're an investor and you want to buy a house in New Hampshire, you might misunderstand. You might think owning a house in New Hampshire, investment property makes more sense because I don't have to de-lead. Kids can move in. That's true until the kid is poisoned. And then when he's poisoned, you got to cough up a ton of money to meet this crazy compliance. Okay, so that's that. See, I'm always yelling at everybody. Okay,
Hey, Andrew, quick question.
yes.
You said owner-occupied single-family home. What about owner-occupied multi-family home, like three-family home? If you're living in it, owner-occupied, do you have to de-lead that house too before kids move in, or no?
In
And
what
the state
state?
can't force you to do it.
Massachusetts?
New Hampshire. I'm sorry. I know Massachusetts you have to because I got screwed. I had to.
Excellent. I can't see who's talking about. Yes, you're right.
Oh, it's my
In
camera.
New Hampshire, if it's an owner-occupied multi-unit property and your child gets lead poisoned, true? Is that what we're talking about?
Yep.
We're talking. Then you would absolutely have to de-lead all the common areas of that property. Oh, that's Mike, right?
Yep.
All the common areas of that property, all the outside, the hallways, the works. The only apartment you could leave with lead in it is the one the kid was actually poisoned in, which is the one the
Sweet.
owner lives in.
Okay.
So,
All right, cool.
but this is why
So the
they've said that,
They can't
Mike,
make it.
because
Okay.
they know that by the time you're de-leading all common area, no one in their right mind would just not finish the whole thing. It's ridiculous.
Yeah.
It's the guys you're already done doing it. Just wrap it up. Yep.
And do they have because again, I had this in Massachusetts. I had a 3-family. I lived in it, but they make you de-lead the whole thing or not de-lead it completely. It has to be lead safe. It can have lead in it as long as you paint over it or whatever it is, but they have to do it. They give you a rebate. So I got $1,500 per floor. So basically I got it for free. Do they do the same kind of stuff in New Hampshire as well?
No,
Of course not. Okay.
no, they don't have the tax breaks like we do, the 1,500 per unit.
Yeah. Okay.
So they
So it's
claim
more
to have
expensive
some
and you don't
lead
get money
money. No, I know you got your tax credit back. In New Hampshire, they claim to have some lead money, but it's right now they have about 3 million, which is stupid for the whole state.
What does that do?
For the whole state.
That's ridiculous.
And that amount of money is not for you because you probably do too well. It's for the really low income neighborhoods where the landlord has to qualify because he hasn't worked in 38 years. But yeah.
I can make that happen.
Yeah, that's true.
Thank you.
Any other questions on that? Now, in Massachusetts, is the seller's disclosure mandatory?
No.
That's true. Not mandatory.
Don't they
Now,
have to do something 3 days before closing?
as far as disclosure,
Yeah.
no, that has to do with the financing. That
Okay.
has to do with HUD and the new rules, but not disclosure. Nope. In New Hampshire, this is actually, you're taking a quick giant flash past my core class. But the New Hampshire core class is a 3-hour course. These are just little pieces of it. Hold on. Here's the form. Okay, now. In Massachusetts, that disclosure form is not mandatory. Sellers might fill it out. Maybe they won't. Maybe they'll spit on it. Whatever they want to do. It's their decision. In New Hampshire, there's another disclosure form. It's similar to Mass. Sellers can spit on it if they want. They don't really need to fill that form out. If they choose not to fill that form out, sellers still have to answer some questions on some other document. They can write it themselves. They can, write it on the back of a piece of bark, as long as they answer some questions. So most people, rather than getting a piece of bark and writing it on there, they use the form, but they technically don't have to, because that form includes information that the seller doesn't have to cough up. The worst state in the country, Debbie, to buy a house for sale by owner? The worst house for sale by owner, Ken, Sarah, is Massachusetts. In Massachusetts, a seller is not required to disclose anything except lead paint problems. Nothing. A seller can know the roof is leaking. They can look at the buyer in the eye and not say a word. If the buyer asks the seller, is the roof leaking? The seller must answer truthfully. Absent the inquiry, the seller is not asked the question. Buyer doesn't ask. Seller doesn't tell. The only thing a seller must cough up would be lead paint information. So that's why many lawyers would tell a seller in Massachusetts, don't fill out those forms. It's loaded with information you don't have to deal with. And the lawyer would say to the seller, you can wait for the buyer to ask you. If they don't ask you, then you don't have to say anything. Now, New Hampshire is similar to that, but they do have a few mandatory cough-ups. Sellers have to cough up lead information in New Hampshire. It's got to come out. Sellers also have to cough up anything about the well that's not good. Even if it's good, just all these questions. Hey, Michelle, what kind of well do you have? I don't know. Most sellers don't even know. Where is it? I don't know. I just turned the faucet on. Is that the way the well is? I don't know. Is it broken? When was it installed? Most answers are going to be, I don't know. So the answer would be, I don't know, which is the truth. Whatever the truth is. The date of the most recent water test. Whether the seller has had experience with problems. And guess what? These answers must be provided to the buyer. Hey, look what it says. Prior to or during the preparation of an offer. So while you're putting together the purchase and sales agreement, you better have the seller already have these questions answered. I wouldn't want to be the agent involved in a purchase and sales agreement without giving my buyer this information before we sign that off, that purchase and sales. Oh, look, here's another big difference in Mass and New Hampshire. New Hampshire no use office to purchase. No, New Hampshire no use office to purchase. New Hampshire use purchase and sales. Massachusetts use office to purchase. 10 days later, you draft a purchase and sales. New Hampshire no do. New Hampshire is you start out with the purchase and sales and that's where it ends. So in Mass, some real estate agents feel the offer to purchase and the purchase and sales might be a little different because you have 10 days to add a few extra things, which is usually not something you're supposed to do. But in New Hampshire, there's no time at all. I mean, that's the deal. The deal is the first piece of paper. Don't be changing your mind. I mean, you should have figured it out at that point. Anyway, here we go. The seller must cough up well water issues. They must cough up insulation questions. What kind do you have? Where is it? And do you have problems with it? Before the offer is put together. You must cough up septic system problems. Those are the three big ones. So New Hampshire, sellers must just, no matter whether they're asked or not, what are the three things? Raj, any remembrance, any recollection of the three? The third one is up on the wall, so that should be simple. Storage, disposal, that's a septic. What's the next one? I'll give you a hint. Insulation. I'll give you another hint on the third one. The well. Well, insulation, and septic. And lead. Don't ever forget lead. That's always on the table in the United States. Now, see this one? How about, does the seller have to cough up information about regulation issues, regulatory material defects in the home, like bad boilers, bad roofs, on-site like radon and on-site environmental stuff. Mold, for instance, mold. Stephanie, who does it say is required to disclose these problems? What's the New Hampshire law say? Who is this? That's you. So it should say, Stephanie Porter shall disclose to a prospective buyer or tenant any material, physical, regulatory, mechanical, or on-site environmental which you are aware of. And hey, Stephanie, when do you have to present this information to the buyer? Before the contract. So that's the same. But this doesn't say the seller is supposed to do this. It's our responsibility to answer these questions. Now, so a lot of people ask me, do I have to tell the buyer that there was a radon test at the home? Yes. Yes, you do. Do I have to tell the buyer that we found some mold? Yes. Do I have to tell the buyer that they're changing the zoning on the street? Yes. All of this stuff. Massachusetts, they don't have, Massachusetts says 93A law. 93A law says you must disclose anything that you think would freak the buyer out. And that's all this stuff we just talked about. Got to tell them everything. Now, in New Hampshire, they got this law that we don't have in Mass. It's called a radon gas notification. So you got to give the buyer these forms that say radon gas is like really bad and you should consider having a radon test. Radon causes 21,000 deaths per year. Radon's the #1 cause of lung cancer in the United States if you don't smoke. So you got to give this radon. This is different. We don't have that in Massachusetts. Look at this. Arsenic disclosure, these words that arsenic is bad. We don't have to do this in Mass. How about this one? Condominium notification. It says, you're buying a condo. Condos are nuts. And before you go too deep into buying this, get your paws on a condo document, on the condo rules and regs and everything, because you may not like what you find once you look through that condo document. That's what it says. Warning, 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 condo, danger, danger. Especially if there's a special assessment that you're going to be stuck with after closing of 50 grand. So here we go. And then there's another disclosure, methamphetamine. Warning, warning. There could be this could be a meth house. I don't know. Warning. Before you buy this house. Hey, guess when you have to give these forms to the buyer? Before the first contract. Warning! Before you make an offer on this house, pal, Mike, I'm telling you, did you ask the seller and did you look into whether or not this house has any solar panel type of contracts that you're going to have to assume and be responsible for? Do you, maybe there's some underlying contracts for solar energy, even if there are no electrical panels on the house? You don't need electrical panels on the house to be tied in to a solar contract. You could have a solar contract. You could be buying renewable energy from the utility company through Eversource, and the previous owner who now you're moving into their house, that house is stuck with a commitment of 15 more years of buying this renewable energy that costs more money per month than if you didn't have this contract. That's what it says over here.
So why wouldn't that be the seller's responsibility to list that?
Because it's not a defect. It's just a different way to buy electrical power. So if you want to know if the buyer, if the seller of this home signed up for these type of electrical contracts, it's your due diligence. This doesn't mean it's bad. It's actually encouraged by the United States to do. So, Hey, did you know, Debbie, on your electrical bill, you can look at it and go, I only pay $225 this month. I think I want to pay $325. Why? Because I want my electric bill to be 99% renewable energy. I want my power to come from the renewable part of Eversource. I don't want it to come from where they burn coal. I want it to come from where they get power from the windmills in the panels in the water. And you go, why would Debbie want to pay more per month? Because Debbie loves the environment. And she's doing this to save the earth. And the poor sucker who buys the house from Debbie is stuck with an underlying deal they can't get out of. That's what this means. Anybody who really loves the environment and you want to spend more money, you could do it today. The utility company go, awesome, you're the best person.
Andrew, in the case of most of these, though, isn't it, if you don't, the law doesn't tell you that you have to look into them. Obviously, if the buyer asks you, you have to answer them sincerely, right? But does any of these say that you have to understand, you have to know these ahead of time, you have to, just say, hey, Andrew's coming to buy this house, you're coming to buy this house, and I'm sitting there going, yeah, it's a great house, this, that, whatever. You don't ask any questions. I don't have to tell you anything unless you ask.
Matt, I'll tell you the difference. What's this called? Matt, what is this called? What is this last word?
Just disclosure for New Hampshire. Yeah.
Excellent. A disclosure is something you must disclose, right? You have to disclose. Okay,
for
look at another word. What's this? Hold on. Let me get what's this word?
That's the notification.
Okay, so a notification is different. I just have to give you this document and then you figure out what you want to do with it.
Mm-hmm.
So Mike, before you make an offer on this house, I just gave you these notifications. Would you like to do something about it? Do you want to have a contingency that you want an extra 3 days to do your due diligence? What do you want now that you know this could be a problem? And Mike might say, yeah, I want to have enough time to look into all these things, and I appreciate that. Mike, you're buying a condo. You just read the condo notification. What do you want to do about it? That I want to do a condominium investigation. Good, let's write it down. Remember the contract I showed you at the beginning? Yep. It said there's a due diligence. All your inspections, you can check off what you want. Mike, what I would check off if I were you is condominium document. Yes, I want that. I want to check off this one. I want to check off the utility tariff. I want to do some due diligence with the utility tariffs. So it's up to you now, but as a real estate agent, as Mike, as a broker, I don't have to tell you what's going on. I just have to tell you this is something you have the right to look into if you want. And
now, are there any other protections on here? Because I know in Massachusetts we have Title V for septic systems.
There's no Title V right now.
Right?
There's a bill on the table to apply something like Title V, but it has not been accepted yet. Approved.
So as of right now,
no.
You buy it, you're not protected. Okay, cool.
No Title V. Nope. So a tariff is along with the pricing plan. There may be certain rules for each tariff a utility offers, such as times or seasons when prices will vary, eligibility for a tariff, when and how customers can join or leave the tariff, what type of meter must be installed to deal with the tariff. All this means is Eversource and National Grid, they all have these programs. They encourage you to buy into them. And they use the money they overcharge you, it goes back into the environmental programs. So, and you see where it says here, when you can get out of it? No, once you're sucked in, you may not get out without paying all kinds of penalties. And that's why the buyer is going to be stuck with it.
Hey, Andy, I have a question. Is there any recourse you have after a buyer has closed on a property if they feel that something was misrepresented according to the listing agent?
Yeah, any buyer can sue you in 2 seconds flat. New Hampshire, 3 years, Mass, 4 years.
Okay.
And if they feel there's been misrepresentation, they will sue you with 93A in Mass or consumer protection in New Hampshire. New Hampshire, they have a 3-year window to file, statute of limitations. Mass, it's a 4.
Okay.
And those cases are constant. If you don't explain in detail everything you know about that home, and you got to really be honest and say, no, I'll lay it all out. If you fail to lay something out that you should have, and they have a problem with it, they're going to get a lawyer.
And then do you feel like you would need something in writing that proved that, you know, the buyer asked the questions in order to support the case?
No, you just have to prove that any answer to their, if they ask you a question and you answer it, do it in writing. And
Yeah.
make sure that you follow up with an email if it's remote. Say, hey, that was a good question. Awesome. So answering the question about the boiler, the seller told me the boiler was, you know, you always need to be the source of the source.
Yeah.
Never be the one giving the answer. I asked the seller responded, and this is his answer. Now, are there any other questions? See, now you have a trail. So later when they say, I asked you a question that, no, in this particular email, it says that you didn't ask me on other questions. And up to this point, you're totally satisfied. So you got to paper trail it.
Okay.
Don't trust anyone. So yeah, this is your biggest problem right now, and I'll leave you with this. It's a segue to next week or next month. When there is no home inspection, and keeping in mind, many realtors think buyers have the legal right to do a home inspection. That is not true. Buyers only have the legal right to do one inspection in the United States. Well, in Massachusetts and New Hampshire, one inspection. Lead paint. That's it. If they ask for any other inspection, like soils inspection for a 21E, you know, anything, no. You don't have the right to do anything but a lead paint. So, Debbie, you don't have the right to even ask for a home inspection. You can ask, but the seller doesn't have to honor that request. They can reject your offer because you had a home inspection contingency.
Is that is that allowed in the state of Massachusetts
To do what?
to tell them they can't have a home inspection?
The seller can say, I will not accept any offer with a home inspection. It's their house. It's not illegal. There's nothing wrong with it. Here's the problem for you, Debbie, and it's already unfolding as we speak, and we'll get into this more next month. When there's no home inspection, didn't happen, buyer moves in, they find all kinds, think about all the problems home inspectors find. They're going to find them on their own, and they're very costly. The buyer is now unable to sue the seller. The sellers do not have a requirement to have disclosed these problems. So the buyer goes to the lawyer and goes, I'm suing the seller. They never told me the boiler leaked. The lawyer would belly laugh and say, you don't have a cause of action against the seller. They are not required to have disclosed that. We're a caveat emptor state between you and the seller. Means let the buyer beware. You, Mr. Buyer, should have asked the seller specifically if the boiler was functioning. You didn't, so tough to you. Well, the roof is also leaking. Tough to you. Oh, the termite damage is like $50,000 worth of sill damage. Tough to you.
Can I
'Cause you didn't do your
elaborate
due
on this a
diligence.
little bit more?
So guess what happens, Deb? Then they asked their lawyer, what can I do? And they said, sue the real estate agent. Because they have insurance, and you can say that the real estate agent discouraged you from doing the home inspection. The agent told you it would probably become a problem if you had it in the offer, because you would have been rejected because there are so many offers on the table right now in 2021. So the agent's the one that gave you that idea to not do an inspection.
Can I ask you a question?
Yes.
So, multiple offer situation, the seller is asking to waive home inspection. I give that information to my buyer. My buyer waives home inspection. Comes up, purchase on the property, a million issues. They gonna sue me?
1,000,000%. Problem is they're going to be upset they overpaid for the house, and now they have $100,000 in problems, or 20, whatever it is. They're going to get some legal advice. And all lawyers, I work with them all the time, they're going to tell you, why don't we write a letter and see what we get? Let's give it a shot. And we can say that the real estate agent gave you some terrible advice and allowed you to move forward without a proper home inspection. I had an attorney sponsor my class 2 weeks ago, an awesome woman from up in New Hampshire. And the student asked her at the beginning, I let him talk for a while, sponsors. And they said, what's going to be the biggest problem? And she said, well, it's already a problem. She said, it's happening now. She's already defending real estate agents now who are being accused of not insisting on a home inspection. And her recommendation was, let an attorney draft a hold harmless agreement. Make the buyer sign it. It's clear. It's the buyer's decision. Totally. In contrast to what you recommend, they decided to do something that you totally disagree with, which is waiving an inspection. So yeah, you got to have some paperwork or you're a sitting duck. You never were a sitting duck before, because how many people waived a home inspection? Hardly anybody. But this is a new world right now. And next month, I'll fill you in on how illegal it is to do partial home inspections. I'll show you evidence, I'll show you the law, and you'll see that those walkabout home inspections is against the law. And home inspectors are going to be beaten in no time as soon as they start getting caught. So I'll bring that up, and we'll cover our bases really well then. And I'll back you up with the law and the statutes, so you can talk intelligently to anybody who's asking you. Thank you guys so much. I do appreciate it. Sure, you got better things to do than hang around with me.
Hey, Andrew, can you do me a favor? Can you send the slide deck to us?
Which one? I just took bits. I took bits and pieces of different programs.
Crap.
What do you need?
I took bits and pieces of notes as we were going through it. So,
Okay.
I mean, whatever you think would kind of work the best.
What's your email address? I'll try to remember
it's
which ones
just
I did. What's that?
Sacco, SACCO @KW.com. Because this is great, because I'm moving up to Nashua, so I'm going to be doing New Hampshire and Mass, and it would be really nice to not screw this up.
What I'll do is I'll work on putting some of these slides that I believe I put up into one little program. Okay.
That's awesome.
Thanks,
you.
man.
Thank you,
I
Andy.
appreciate it, Andrew.
See you soon.